Namaskar and welcome to our channel of the School of Legal Luminaries with your host Noyana. Now let us dive ourselves into the series named Offences Against Property, which is described under Chapter 17 of the Indian Penal Code. This episode of the series will be dealt with the offence named as extortion under Section 383 of the Indian Penal Code. Now let us understand the subject matter of the offense of extortion through its purpose and mode. The main purpose of this offense is to intentionally extort, or you can say taking away any property, either movable or immovable, or any valuable security, or anything signed or sealed which may be converted into a valuable security. Herein, intention is very much necessary, because only when there is the presence of mens rea a crime is been committed. And here, what's the crime? To extort the movable or immovable property. The very definition of movable property is given under Section 22 of the Indian Penal Code, which states that a movable property is a corporeal property of any description except land and things attached to the earth, or permanently fastened to anything which is attached to the earth. But simply for our layman's understanding, we will be sticking ourselves to the literal meaning of movable. That means something which can be moved from one place to the other. Or immovable property means something which is very much fixed. Okay, then for layman's understanding, let us understand what this valuable security means. It is a sort of document which may be, sale deed, a rent agreement, or a mortgage deed. Clear? But the actual definition or the actual meaning is being defined under Section 30 of the Indian Penal Code itself. And finally, let us come into the mode, how this offense is been executed, and in a very nutshell we can state that it is by blackmailing. How blackmailing is done? By putting a person to fear of any injury. That is, the accused person is putting another person to fear of any injury, and that injury may be bodily injury, may be an injury to mind or reputation or property, which is described under Section 44 of this very code itself. And finally, the very important portion or the subject matter of this offense is the concept of dishonestly inducing to deliver. The concept of delivery is very much important. Okay, dishonestly inducing to deliver to any person, any property. Okay, property here means movable or immovable, or any valuable security as described in the Section 20, as described in the Section 30 of this Penal Code, or anything signed or sealed which may be converted into a valuable security. Clear? And herein the concept dishonestly is described under Section 24, which says that whoever does anything with the intention of causing wrongful gain to one person or wrongful loss to another person is said to be doing that thing dishonestly under Section 24. Clear? And a very important takeaway from this slide is that the offense of extortion is only completed when the delivery takes place. The concept, the delivery of the action takes place, and the delivery must be made by the person who is put into fear. Clear? And let us understand this very subject matter very properly in an elaborate sense in the coming slide through certain illustrations and case laws. Now let us understand the very subject matter or the ingredients of the offense of extortion by certain illustration. Okay, number one illustration is described here, which you can see is A, who is an editor, threatens B, a politician, to publish a defamatory statement unless the politician gives the journalist some money, some amount of money. Here the journalist, that is the editor of a paper, of a newspaper or press, is said to have committed an offense of extortion. Clear? Now here to me, I'm giving another illustration here to me very properly. A, by putting Z in fear of an injury. Injury, what type of injury is? Grievous hurt. Dishonestly inducing. Remember the very subject matter or the very mode how an extortion is being done. Here, A, by putting Z in fear of grievous hurt, dishonestly induces Z to sign or affix a seal to a blank paper and deliver it to A. Z signs and delivers a paper to A. Here, the paper so signed can finally be converted into a valuable security, may be converted to a sale deed or mortgage or whatsoever. And here it is been found that A has committed the offense of extortion. Clear? Now, a very important takeaway is that to constitute an extortion, there must be the very element of threat by the accused. It is not necessary that the person who is threatening should receive the property himself. It may be indirect. How? Let us understand by going into the subject matter of the Ashok Kumar versus Jagat Chande case. Here in this case, a sub-inspector of police has wrongfully arrested a person and threatened that he would not release unless the money is paid. The police inspector was held guilty of the offense of extortion. Clear? And now again let us go into the Chandarkala versus Ramkishan case, wherein the headmaster of a school called her, a lady teacher of a school itself, to a place where he was alone and induced her to sign 3 blank papers by threatening an attack on her modesty. And herein the Supreme Court held that the accused, the headmaster Chandarkala, is been found guilty of the offense of extortion. Then something or a case wherein we can say there is the absence of the commission of extortion is the subject matter of R.S. Nayak versus Antule case, wherein you hear to me very properly. The Chief Minister Antule asked the sugar cooperatives whose cases were pending before the government for consideration to make donation and promise to look into their cases. Finally, if the donation is done, it was held by the Supreme Court that this facts did not constitute offense of extortion, as there was no evidence at all that the management of the sugar cooperatives had been put in any fear or contribution had been paid by them in response to the threat given by the said minister. Clear? So this case states that there is the absence of the element of extortion. And finally, let us also go into the Ramachandra case, wherein in this case the accused had written letters to a person who had been a father of a daughter, stating, enclosing the photograph of that daughter in a very nudity, and said that if it is made public would definitely, undoubtedly affect the reputation of that girl as well as the father. So the accused demanded very harsh money from the father and threatened him, stating that he would circulate the photographs to the relatives of the girls and the public and make it public, and if the money was not paid, herein directly the accused is convicted of the guilty of extortion. So by this discussion, it is the very subject matter of the offense of extortion is been understood by us, and hopefully the laymen or the common people who are not aware of the sections or of the provisions of the different acts have at least understood some or the gist of the concept of the offense of extortion, right? And now I am going to the next slide, which is very. Now let us dive into the topic, that is the differences between theft and extortion, which is very much important for the students who are appearing in the judicial competitive exams, that is the difference between theft and extortion. In theft, possession is obtained without consent, and here in extortion, possession is obtained by intentionally putting a person in fear of any injury, and thereby the consent has been obtained. That is, here in theft, no element of force or compulsion is used, and in extortion, there is a very presence of element of force. And here in theft must be done in parlance to the movable property as stated under the section 22 of this very code 1860. And on the other hand, the extortion can be done over to any kind of property, may it be movable property, immovable property, valuable security, or any document which is to be signed or sealed, which can be further converted into a valuable security as discussed or defined under section 30 of this code 1860 itself. Clear? And one of the very important differences that in extortion, minded, the victim is induced to deliver the same to the offender to or to any other person, but in theft, the offender himself moves the property in order to such taking. Okay, so this is very important for the examination purpose as well as for clearing the concept of the both, that is theft and extortion. Finally, let us discuss the takeaway points of this very lecture of section 383 of the Indian Penal Code. That is, we have understood the ingredients of the offense of extortion by understanding the subject matter of it through its mode and purpose. Then we have also learned the definition of movable property, dishonestly valuable property, and injury through section 22, 24, 30, 44 of the Indian Penal Code 1860 respectively. And finally, we have understood the very differences between theft and extortion through important illustrations and case laws for the educational purpose, as well as we have as a whole understood the gist of extortion, of the offense of extortion under criminal law. Hope we are able to deliver a productive session to the people at large as well as to the students in particular for their examination purpose. For feedback, kindly drop your comments how we can improve it further and what are the requirements of the public. Thank you and stay tuned for the coming lecture series under our School of Legal Luminaries. Thank you, bye-bye and take care.